Intellectual property. What is it? How is it protected? Why does it matter? These questions are common, and their answers form the basis of how intellectual property works in favor of the creator. By the time this video is finished, you'll have a fundamental understanding of the 4 types of intellectual property protected, how to protect each one, and you'll even see some examples of why protecting intellectual property is so important. Let's start with the basics. There are 4 basic forms of intellectual property: patents, trademarks, copyrights, and trade secrets. Each has its own scope, quirks, and value, and there's a lot to learn about each type. This is just a video to get you oriented to the world of intellectual property, so we'll stay out of the weeds. Another important thing to consider is ownership. If you create something at work or using company resources, that creation belongs to the company. You can get credit for its creation, but you won't have automatic ownership of the creation. IP can be bought, sold, licensed, and assigned just like any other piece of property. Who owns it, who has permission to use it, and in what ways can get pretty complicated. Now for the good stuff. We'll dive in first with patents. Patents are probably the best example of IP operating as a negative right. A patent for a method, invention, or process gives the owner the exclusive right to do what's laid out in that patent. If someone else does what's laid out in the patent owner can sue them, either for money or to get them to stop, or both. The United States is what's called a first-to-file jurisdiction, meaning that whoever files the patent first gets priority. This important distinction means that filing your application as soon as you can is critical to protecting your rights in the patent. It also means that it's important to keep any activity and information surrounding a patent or a potentially patentable invention on a strictly need-to-know basis. Bummer. Importantly, there are 5 requirements to qualify for a patent: patentable subject matter, usefulness, novelty, non-obviousness, and enablement. Those sound a little intimidating, but have no fear. We're going to break them down one by one. Let's move now to trademark law. Trademarks are source identifiers. From slogans to images to company names, anywhere you see the little TM or circle R, sometimes called an R ball, there's a trademark involved. There are 2 broad categories of marks: those which are inherently distinctive and those which require secondary meaning. The lowest form of trademark recognized is what's called a generic mark. Think of buying items at the grocery store. When you buy apples, they're called apples right on the crate. The law affords no protection for generic marks. And importantly, a generic mark can never obtain secondary meaning and will always be a generic mark. Just above generic marks are marks that are descriptive. Going back to the grocery store, think about buying crackers. Using the word salty in connection with crackers would be a descriptive of the product and would therefore be a descriptive mark. Descriptive marks are only given protection when they acquire secondary meaning. Secondary meaning is important here because it signifies whether the descriptive mark has remained merely descriptive or whether it has become a valid trademark. The key question is this: do consumers associate the term with the company as the source of the goods and services? This usually requires a lot of evidence to prove, and it takes a long time to build up the necessary evidence. Let's move now to copyrights. To be eligible for a copyright, you must have an original work of authorship fixed in a tangible medium of expression. Commonly, things like movies, music, software, books, artworks, and plays are all subject to copyright protections. Copyright attaches to a work automatically, as soon as it is fixed. This means that it must be able to be perceived, whether by way of seeing or hearing the work. Lots of things we do every day fall under copyright protections. Emails, presentations, spreadsheets, memos, all of these things are automatically protected by copyright law. The final form of IP we're going to talk about are trade secrets. There's no statute that tells us what trade secrets are, but they're pretty easy to understand. A trade secret can take the form of a formula, a method, a recipe, or some kind of process that you want to keep a secret from your competitors. Thanks for watching. And as always, if you have questions about anything discussed in this video, reach out to your legal department.